क्या है? Why is it in top 10? Is this to be finally heard or it is a short matter? It will take time. What prayer have you made? Reinstate. This will have to be finally heard. Pleading sab hai complete. Time is short today. Part-heard matter is. So time is short today in view of another part-heard matter. Put up on when do you want it? January. 3rd January. Top 10 cases. Number 2. What is this? ये तो वाला है selection वाला. Can't be heard today. Sorry. There's a part-heard matter I have to conclude. This will also not conclude today.
There is a dispute with regard to the characters of the answer of the question. The option may refer it before the expert opinion. Otherwise,
Third expert तो होगा नहीं. I am not willing to refer matters to expert on my own because of my own personal doubts. We'll refer it to their expert. They say it is there. You want to take a chance? You can take a chance on perhaps. How many days this will take?
1 day.
1 day. Third. Let it come up on 3rd January. 3rd January top 10. See one. No. I have not heard it. If you know something more than I do, then that's. We'll see in January. I don't know. It's not possible next week, but there will be transferred matters and we will have to prioritize that fresh. Next week I will not be able to take up my own list. It's not likely. ये क्या है?
There is a dispute with regard to only 2 questions.
Is a further affidavit to bring on record another report of the expert consulted by the board. Comma is under preparation. On his request, put up on 3rd top 10. Huh? 4th कर देंगे. 4th top 10 cases. Just 1 minute. Yes, Mr. Standing Counsel. They have not done. Standing Counsel has not done anything. ठीक है, so we will take them to task. He is filing an affidavit. He is saying, आपने किसका लगाया है? Assistant Director. What does he say in which paragraph? Pursuant humbly of the post in this treated advertised 63. Select list of selection and subject English declared by recommendation for placement of selection. So we are asking you how many 2% से आप कितना करेंगे? 160 आप कहेंगे, आप जनरल कैटेगरी हैं, तो जनरल कैटेगरी में 2% जब लेंगे तो 50 का लेंगे ना।
लगता है वो टोटल वैकेंसी पे लगता है, जितने लोग होते हैं, जैसे जिस कैटेगरी का जो होगा,
तो how will that be allocated within the subcategories? This is horizontal.
तीन पोस्ट है, तीन पोस्ट अगर तीन भी मिल जाते हैं जनरल कैटेगरी के, तो तीनों जनरल कैटेगरी से जाके मान लिया जाएगा कि हार्जेंटल का फुलफिल हो गया।
क्यों? अगर
यही
नहीं, सिस्टम क्या होगा? आई एम ट्राइंग टू अंडरस्टैंड। अगर ये ईडब्ल्यूएस है ना, बस फ्रीडम फाइटर, ऑलराइट, तो डिपेंडेंट ऑफ फ्रीडम फाइटर को हॉरिजॉन्टल मिलेगा, मगर कैटेगरी वाइज नहीं मिलेगा। बट
चले जाएंगे तो इफेक्ट पड़ेगा, जैसे कि अगर तीन पोस्ट बनती है, 3 है, 5 है, 7 है, जो भी है, अगर एक ही कैटेगरी के साथ मिल जाती मेरी पहले नहीं बनेगी, सिलेक्शन कर लिया जाएगा। अगर फ्रीडम फाइटर है जो
पहले किसमें अप्लाई होगा?
पहले किसी का अलग से अप्लाई नहीं होगा, पहले सिलेक्शन कर लिया जाएगा, 50% रिजर्व का, 25% ओबीसी का और एससी कर लिया जाता है। उसके बाद देखा जाता है कि अगर मान ली 5 पोस्ट है, फ्रीडम फाइटर हो गया, कोई भी
एक ही लेके चलो,
कोई भी आइडेंटिटी हो, देख लिया था कि उसका इतने में तीनों में क्या कितने लोग आ गए हैं, कितने सीनियर के रिक्वायर्ड थे। अगर आ गए तो मान लिया जाता है कि आइडेंटिटी मिशन कंप्लीट हो गया, अब वाला सीनियर जो नहीं है। अगर नहीं आए तो देखा जाता है कि जो बचे नीचे के जो रिलेटेड नहीं है, उसमें उस कैटेगरी कौन टॉप पे है, उसको उठा लिया जाएगा और अपने कैटेगरी
किस कैटेगरी में टॉप?
जिस कैटेगरी जो रहेगा उसी कैटेगरी में डाल
अरे भाई,
जैसे एससी का है, तो एससी में डाल दिया जाएगा।
अच्छा, उस कैटेगरी का लास्ट पर्सन आउट हो जाएगा।
क्योंकि इससे कहा जाता है इससे कोई इफेक्ट नहीं पड़ता,
जिस कैटेगरी का हाईएस्ट अवेलेबल है,
हाँ उसी होता है।
he will replace the last candidate in his category, other category. If he is a general category, he will replace in the general. If he is scheduled caste, in the scheduled caste. तो आप ये चीज क्यों नहीं बता पा रहे? ये तो कुछ और कह कुछ और रहे हैं। ये तो कह रहे हैं अगेंस्ट 166 पोस्ट 2% would mean 2.66. 2.66 if you round off it becomes 3.
आप बताइए कोई पोस्ट खाली है नहीं,
वो तो नहीं पूछा,
जिसके 22/11/2022 को इसके बाद में क्या है कि हमको हमने 28/10/2022 को ही पूछा था, अभी तक कुछ नहीं है।
total vacancy that may be available for appointment.
क्या कोर्ट सेटिस्फाइड कि मेरी सेटिस्फाइड जो लेता कि कोई वैकेंसी खाली हो तो वहां को कर दिया जाए, ये इसलिए पूछा था।
नहीं, ये तो आपने वो जान लिया जो हमें भी नहीं पता था। हमने तो ऐसा कुछ नहीं सोचा था जब ऑर्डर लिखाया। ठीक है, just wait. Please wait. I have something written in black and white. I can recollect what was in my mind. Please wait.
I was not doing just after reading the argument. Page 60. It is the final list. In the bottom, at serial number 63, page 61, one DFF category under the unreserved.
Where are you reading?
Page 61.
Serial number
63.
पूजा शुक्ला।
Thereafter, page 62.
ये क्या मतलब है?
Either they have divided into two parts, one in the reserve and one in the unreserved, applied both the 2% in both differently. 2% in the unreserved category and 2% in the unreserved.
So the total may not match up.
That
is what is happening. तो इन्होंने ये DFF is अच्छा फ्रीडम फाइटर, तो इन्होंने एक 63 पे आ गए, एक ये 643 पे आ गए, और
one post in the unreserved category and one in the reserved category.
तो इन्होंने
क्यों divided into two parts?
63 का 2% ले लिया, तो वो 1.5 से नीचे होगा, तो इन्होंने राउंड ऑफ कर दिया। अब रूल क्या है? What he says is that the rule is to be, the horizontal reservation is to be applied to the total vacancy. वो तो आप कहीं कह ही नहीं रहे। अरे प्लीज वेट, आई हैव नॉट डिसाइडेड एनीथिंग. All right. Shri Neeraj Pandey, Standing Council, prays for accommodation to examine if 2% reservation, horizontal reservation for dependents of freedom fighters was to be applied to the total vacancies or to this or category wise. Full stop. On his request put up on 20th in top 10 cases. अगर खाली है मगर आपका राइट नहीं बनता, आप बीएफएफ नहीं है तो नहीं है. That is another thing that I had required. See, these orders that without granting interim orders are not for the really for the bar. It is for the judge's own recollection more. Alright, I don't have a great memory, so I forget. So I write it. अब आप कहिए कि नहीं आपने इसलिए लिखाया था कि मतलब ये बात जरा से जाती है. नहीं, आपने हमने इसलिए नहीं लिखाया. आपको हम बता नहीं रहे कि क्यों लिखाया. Which one is this? हाँ, आपने क्या एफिडेविट्स ला रहे हैं? Mr. Tripathi, have you been able to go through the affidavit that the state is proposing to file? चलिए तो आप देख लीजिए क्या कर रहे हैं. अभी दे रहे हैं एफिडेविट आपको? We'll have it on 20th. किसके कितने एफिडेविट फाइल कर रहे हैं मिस्टर सिंह? Pursuant to the last order, affidavits of respond numbers, personal affidavits of respond number 4 and 7.
4 and
1 and 4. Comma 5 today taken on record. Personal affidavit of respond number 1 and counter affidavit on behalf of respond number 7. 4. Comma 5 today taken on record. Learned counsel for the petitioner may go through the same. On his request, anything on the request of learned counsel for the petitioner put up on 20th in top 10 cases. कोर्ट का हुआ, आप कुछ अरेंजमेंट करेंगे. वो छोड़ दीजिए, वो इंप्रेशन आपको लग रहा है कि वो हमें वर्क कर रहा है, माइंड पे नहीं कर रहा है. आई एम मोर कंसर्न नाउ बाय दिस. हाउ आर यू गोइंग टू डू दिस? There is law against you by the Supreme Court that once you take the responsibility on yourself, you have to discharge it. You can't say that colleges cannot recruit because we have made a law providing for a commission that will recruit. हाँ, ये तो वाला है.
इसमें जो है एक पहले कोर्ट ने ऑर्डर कर दिया था कि जितनी वैकेंसी बच गई उनको
हाँ, तो उसमें इन्होंने कहा कि वो इन्होंने DIOs ने एडवर्टाइजमेंट करके कहीं नेक्स्ट डेट पे क्लियर कर 20 टॉप 10
नंबर 6 इनका बशीर नारायण पांडे करके शाहीन का कुमार.
ये क्या है? 62515 में हाँ, ये 62515 में यही मेन है. ठीक, petitioner आ गए, आज उनको तकलीफ तो नहीं हुई? Mr. Standing Counsel, please inquire, was any arrangement made for him today or not? Today also he comes like the same. कुछ नहीं arrangement.
नहीं, अरेंजमेंट इनका ये था कि इनको वहाँ पर पहले सूचित करना था। कह रहे थे कि एसआई से हमने कहा, हमने कहा एक्चुअली वहाँ पर सबको लग रहा है बोर्ड पे लगवा देते हैं हेल्प केस
सरसुरारी, हाँ,
page 73 in the order passed by the Joint Director.
promote the petitioner on the post of lecturer Sanskrit. हाँ,
Page 73 in the order passed by the Joint Director. Operative portion page 77.
कुछ बेसिक फैक्ट दे दीजिए तो जरा सर, ये किस पोस्ट पे पॉइंट हुए थे, क्या हुआ?
Petitioner was selected by the UP Secondary Education Service Selection Board on 8/9/2005.
Petitioner selected by
Board
UP Secondary Education
on 8/9/2005
on the post
of 80 grade teacher. In compliance of the same, appointment letter was issued on 13/9/2005.
where Shri Shiv Mohar Nath.
In respondent number 4.
All this. Just one. Yes.
In the institution, 4 posts of lecturer have been sanctioned by the department. The details have been mentioned in paragraph 4 of the petition.
So he was assistant teacher, lecture, LT grade, which subject?
Hindi.
Hindi. All right. 4 posts of lecturer are sanctioned.
Ji. 1 post of lecturer vacant on 30th June 2011 due to retirement of
On 30th June
Ji.
2011.
11 due to retirement of Gangamba Mishra.
All right.
The petitioner set up a case for promotion under 50% quota.
How many of 4? How many were direct?
How 2 comes under the direct quota?
No. But so there is no violation of that.
Ji. At that point of time, no person was promoted under the promotion quota. Now the claim has been rejected by the subsequent order on the ground that adverse entry was awarded by the management. And 1 increment has been stopped, therefore he is not eligible. The third round of rejection is
Adverse entry ये है 1 increment plus 1 increment.
G plus 1 increment has been stopped. And apart from the third round is that the post has been notified to the selection board, therefore
वो तो हो नहीं सकता.
G.
तो
The apportionment order has been passed by the Joint Director alone, whereas under section 12, committee has been constituted by the
Joint Director has passed the order.
G. Committee has been constituted under section 12 of UPN number 5 of 1982 for considering the case of promotion.
Committee
Under section 12 of UPN number 5 of 1982 for considering the claim of the promotion.
result.
So far the adverse entry part is concerned, I have stated in the paragraph that at no point of time any adverse entry was communicated to the petitioner.
Paragraph.
In paragraph 14, 17 and 18, and nothing has been mentioned in the service book of the petitioner also.
All right.
So far the stoppage of increment is concerned, the stoppage of increment is different thing that non-payment of stoppage in a particular year. My 1 increment has not been paid fixed by the management. Now the management has set a case that 1 increment has been stopped. So far the stoppage of increment is concerned.
There is no order.
No, कोई order नहीं है उसका.
They have not
paid fund increment.
Paid. That is another thing.
That is another thing.
But there is no order of.
No order.
Where have you stated?
I said in paragraph 14, 17,
उसी में.
उसी में सब है.
All right.
और जो स्टार्टेज की बात होगी तो वो punishment माना जाएगा.
It has to be done through in accordance with the disciplinary rules.
जी.
वो हुआ नहीं.
जी वो नहीं हुआ. काउंटर में इस फैक्ट का कोई रिलायंस नहीं है.
थर्ड फैक्ट क्या कहते हैं? तीसरी चीज क्या कही है?
तीसरी चीज हमें ये
पोस्ट नोटिफाई हो गई, वो
नोटिफाई हो गई, इसलिए प्रमोशन नहीं हो सकता.
तो वो आप जजमेंट पे रिलाई करेंगे.
वो पोस्ट नोटिफाई नहीं है तो प्रमोशन होगा. अगर एलिजिबल है तो प्रमोशन करेंगे, अगर एलिजिबल नहीं है तो नोटिफाई होगी.
तो इन्होंने करना इनकी जिम्मेदारी थी, इन्होंने नहीं करी तो दैट विल नॉट कन्फर एनी राइट.
जी. पेज 77 का अपडेटेड पोर्शन है.
यस. विवेचना.
जी. अपीलकर्ता का निश्चय और संस्था प्रबंधक प्रधानाचार्य द्वारा उपलब्ध कराए गए कथनों के अनुसार अपीलकर्ता की लागू इस नियुक्ति माध्यमिक शिक्षा सेवा संघ बोर्ड द्वारा दिनांक जितना को सहायक अध्यापक नियुक्ति के पद पर की गई. नियुक्ति से 10 वर्ष की सेवा पूर्ण किए जाने के पश्चात इनकी संतोषजनक सेवा न होने के कारण प्रबंधक द्वारा इन्हें चयन वेतनमान का लाभ नहीं दिया गया. वर्ष 2005, 6, 6, 7, 7, 8, 8, 9 में विद्यालय के तत्कालीन प्रधानाचार्य द्वारा प्रतिकूल दृष्टि प्रदान की गई थी तथा सीनियर द्वारा संस्था विरोधी
सिलेक्शन ग्रेड कह रहे हैं तुम. सिलेक्शन ग्रेड कह रहे हैं तो चयन वेतनमान का लाभ नहीं दिया गया.
नीचे पदोन्नति की भी बात है.
अच्छा ये वाला है. ये आपका एडवर्स एंट्री को कह रहे हैं.
हां एडवर्स एंट्री के कारण सिलेक्शन ग्रेड नहीं दिया और सिलेक्शन के बाद दिया जाने का प्रमोशन नहीं दिया. नीचे वाला का एडवर्स एंट्री की बात जो स्टैट्यूट में प्रोविजन है प्रिंसिपल है फॉर गवर्नमेंट.
Which statute?
Under chapter 3 of the regulations framed under the Intermediate Education Act.
Yeah.
72 relates to the adverse entry. In the case where an adverse entry is made in the lighter role of a person in a particular
Communicated in not good function of the body of the indicator. Yes.
कहीं कोई कम्युनिकेशन है नहीं.
इसका कॉन्सिक्वेंस कहीं कंसीडर हुआ है?
नहीं.
है ना. तो जुडिशियल कंसिडरेशन हो चुका है किसी केस में. अगर एडवर्स एंट्री कम्युनिकेट नहीं करेंगे तो कॉन्सिक्वेंस क्या होगा?
वो जजमेंट नहीं आया है. सिलेक्शन ग्रेड पे लाया है. संतोषजनक सेवा जो कंसीडर हुई है एक जजमेंट में है. वो जजमेंट है. ये जो संतोषजनक सेवा का कांसेप्ट है 2001 के गवर्नमेंट ऑर्डर से वो एक जजमेंट है.
नहीं तो संतोषजनक तो होने का एडवर्स एंट्री बेसिस है.
जी.
एडवर्स एंट्री आप कह रहे हैं कम्युनिकेट होना जरूरी है. यहाँ तक कोई दिक्कत नहीं बिकॉज ही हैज अ राइट टू रिप्रेजेंट अगेंस्ट दैट आल्सो. ऐसा नहीं है कि इट इज जस्ट.
हाँ वो उसके अगेंस्ट रिप्रेजेंटेशन है.
ये आप कह रहे हैं इसमें क्या होल्ड हो गया?
इसमें ये कहा संतोषजनक सेवा में एडहॉक पीरियड भी इसमें कोर्ट में काम कर लिया.
वो तो ये कह ही नहीं रहे इसलिए वो जाने दीजिए. सेकंड स्टॉपेज ऑफ इंक्रीमेंट.
वो स्टॉपेज ऑफ इंक्रीमेंट का कहीं कोई डिटेल नहीं है. देखिए साथ से स्टॉपेज ऑफ इंक्रीमेंट है
वो है. सो लेट अस सी पैराग्राफ्स 14, 17 and 18 of your writ petition.
That in the service book no any adverse entry has been mentioned and the said adverse entry has not been communicated to the petitioner. Therefore
अगर सर्विस बुक में रिकॉर्ड लगाई है आपने क्या?
ये सर्विस बुक हमने रिकॉर्ड लगाया है.
पेज इसमें तो नहीं है. रिजॉइंडर में लगाया है क्या?
रिमाइंडर में है एग्जैक्टली पेज 19.
What do they say in reply in paragraphs 14, 17, 18? 14 is matter of record. 17 relate to order of honorable court. Then Mr. Standing Counsel, you have practically admitted. Just wait, just wait. We're still not calling upon you. Now you have annexed the service book also.
जी पेज 19 पे रिमाइंडर में.
There is no adverse entry here.
पेज 22 पे एक एंट्री है दाहिनी तरफ. नीचे से 4-5 लाइन लिखा है इन राइटिंग में इनका योगदान देखने में मेरा
चरित्र उत्तम रहा.
ये उत्तम है. इसके बाद नेक्स्ट पेज पे
Maybe they are being sarcastic too.
ये 24 पे एंट्री है उसी को ही एडवर्स एंट्री कहते हैं. 24 पे ऑलमोस्ट इमीडिएट समय से कक्ष में न जाना, शिक्षक कार्य करने में अक्षम, आदेशों की अवहेलना, कर्मण्य कर्तव्यों के प्रति उदासीन, छात्रों के समूह विषय के अतिरिक्त व्याख्यान। ये एक इंटरेस्ट महिला बैंड इंटर्नशिप के साथ है।
कब की है?
ये इसमें कोई डेट भी नहीं है, ये है 2008 के बाद की है।
ये किसके कॉन्सिक्वेंस में आ गई? चलिए, एनीथिंग एल्स? बताइए मिस्टर शर्मा। How many will be reserved for promotion? 2. How many are there on promotion? Of the rate? $57 of the rate. Yes. पदोन्नति से पदोन्नति से पदोन्नति से। आपका प्रमोशन ड्यू कब हुआ?
2011 में जगदम्बा प्रसाद मिश्र का पद है, इसके लिए हमने
आपने इसके अगेंस्ट अप्लाई करा?
सर मान लिया जाए कि इस पद के लिए एलिजिबल है, उस समय भी 3 पद पदोन्नत द्वारा भरे हुए थे।
2 और थे, चारों थे।
ये जगदम्बा प्रसाद तो सीधी भर्ती द्वारा थे, इस पद के खिलाफ
हाँ ठीक है, सीधी भर्ती से।
वो सीधी शेष 3 पद जो है पदोन्नत द्वारा भरे
चल रहे थे।
उस समय तो
नहीं हो सकता,
नहीं था
ये बात तो।
और 12
तो आपके ऑफिसर इतना सब क्यों लिखाते हैं?
2011 में ही पोजीशन हो गया है।
हाँ वो ठीक है, वो तो फिर रिक्विजिशन रहेगी
जी। 7 का जरा एवॉल्वमेंट देखिए, ये तो मैनेजर का लेटर है, कुछ भी पैरा 7 में हमने लिखा है लिख के कि उस समय कोई भी 2011 में कोई भी पदोन्नति के तहत कार्यरत नहीं था
ना हो है ये काले
मेरा साथ।
They have not denied it. आपने इसको लगाया लेटर को, इसको क्या कहा? इसको चैलेंज किया कि ये गलत है?
हमने तो ज्वाइंट डायरेक्टर एजुकेशन को
ना 7 दिखा, 7 को आपने कैसे डिस्क्राइब किया? During course of hearing before the institution has submitted details of the post which has been accepted that out of the 3 were filled up by the others, 1 was filled up by recruitment, and then all the 4 are photocopy of them. तो आपने इसको डिस्प्यूट नहीं कर रहे करेक्टनेस, आप नहीं कह रहे कि इन्होंने गलत गुमराह किया वहां जाके। आप कह रहे हैं नहीं, आप तो ये स्टैंड ले गए गलत ही, सही आपकी पिटीशन थोड़ी बनाई हुई है, आपकी है। अच्छा, तो ये थोड़ी स्टैंड लिया कि ये जो 4 पोस्ट हैं ये गलत डिस्क्राइब कर दी। इफ यू एक्सेप्ट, आपने ये माना कि जिस दिन प्रमोशन कंसीडर कर रहे हैं उस दिन वैकेंसी अराइज कर देंगे।
नहीं, हमने ये भी कहा कि उस दिन इसके इस पद के अतिरिक्त कोई पदोन्नत का पद
तो आप कह रहे हैं, मगर आप डॉक्यूमेंट से उसको कॉन्ट्रडिक्ट कर दे रहे हैं।
ये डॉक्यूमेंट हमारे लिए एक मैनेजमेंट के ज्वाइंट,
आप इसको कहीं नहीं रहे कि इन्होंने गलत फैक्ट्स लाए। एनीवे, सो देन व्हाट डू यू वांट टू से? हाउ विल यू एस्टैब्लिश दिस? दिस इज बाय द management. What does your officer say? Bring that on record. आपके पास रिकॉर्ड है ना? ऐसा तो है नहीं कि इंस्टीट्यूशन क्यों? What does your officer do? Pay salary to people without having any record? That will be a misconduct. No, वो तो कुछ है नहीं। वो तो उस पे अगर आप बहस करना चाहते हैं तो अलग बात है। इस पे आप रिलाई कर रहे हैं, तो your officer will have to tell us on the strength of his own record कि on the day when the vacancy arose of Jagdamba upon hearing the counsel and counsel at some length, it transpires, the petitioner claims on 36/2011, comma, no person other than Shri Jagdamba Prasad Mishra was working as lecturer at Shri Shiv Mohar Nath Pandey Kisan Janata Inter College, comma, Nagar Bazar, comma, Basti, on promotional post. Full stop. Upon the retirement of said Jagdamba Prasad Mishra, comma,
You are direct.
उनका कहना तो ये है ना,
अच्छा जी.
the post became vacant to be filled up through promotion under 50% promotion rule, under 50% quota rule. Full stop. Promotion quota rule. Full stop. On the other hand, learned additional chief standing counsel refers to communication dated 4/9/17 appended to the writ petition to submit, comma, on that date, other than Jagdamba Prasad Mishra, the other three candidates, namely, other three lecturers, namely Shri Krishna Chand Shukla, comma, Shri Shyamlal and Shri Gajadhar Nath Mishra, had been promoted to the post of lecturer and were available and were working at the said institution. Therefore, it has become necessary to ascertain the correct position as to the source of appointment of lecturers at the above institution and the availability of such lecturers on 36/11. And in addition, the standing counsel may file supplementary counter affidavit of the DIOS. DIOS Bareilly. नहीं, बस्ती है, बस्ती, to bring on record the correct position with respect to the fact doubt expressed above. Put up on 3rd January. कर लेंगे. 10th in top 10 cases. What about the other cases? वो पता नहीं क्या है. पहले कर लीजिए. You cannot do it next week. क्यों ना? अच्छा, ऐसा नहीं. This is for a person in service. That is matters a lot. It matters a lot. It upgrades his status. ऐसा नहीं है कि अभी, but I feel अगर आप कर सकते हो तो next week कर दीजिए. इतना ही. 10th रखिए ऐसा क्या? 10th January. Top 10 cases.
Number 7. Mr. Mayak Singh, Mr. Shaker,
Mr. Punam Ganguly.
Filing counter today. Counter affidavit filed today, taken on record. Put up on 3rd January. Top 10 cases.
Because the petitions have been legally superannuated, and the matter is not by
Put up on 3rd. No, sorry, 20th.
The last line of the last order may be repeated. Last line of the last order may be repeated in this order.
What is that?
Dot.
Obviously.
Right.
Second list पे top 10 list है.
Bill number 137, yes, out of 10 cases serious. Mr. Satprakash Singh, Mr. Vinay Kumar Shivani, other side, Mr. Sanjeev Kumar Pandey.
क्या है? You are for petitioner. In which petition? 16158 you have received counter. Always counter. कब फाइल किया है? Mr. Satyaprakash Singh. Counter affidavit filed on behalf of respondent number. इन्हीं का आना था बस. File today taken on record. 6 का क्या हुआ? Learned Standing Council praised and is granted. हाँ? कब फाइल किया? State case file counter on 26 November 22. Office to trace out the same and place on record. Learned Council for the petitioner praised and is granted. 2 weeks time to file rejoinder affidavit. Full stop. List on. Huh? Any agency now? 10th January 22 in top 10 cases कर दीजिए. AP काट कर दीजिए ऊपर. Office report release. Notice has been served on respond number 6. None has appeared on that. Interim order तो आपका ही till the next date था. तो last date भी क्यों नहीं बढ़ रहा है? नहीं. अच्छा इन्होंने ही कराया. All right. Interim order granted earlier is extended till the next date. तो 10th की जगह आगे चलिए 17th पे टॉप है.
17 number 138 किसका है?
उनका एप्लीकेशन क्या है? उनका एप्लीकेशन
सॉरी भाई है मगर आज कहाँ से नहीं क्या मैटर क्या है? Retirement benefits herein consider and decide the claim. Amendment है इनका. Amendment का काम आएगा फिर काउंटर आएगा. भाई अब आप अमेंड करेंगे ना. रिजेक्ट कर दिया है. ठीक है. ऑलराइट. Amendment application number 2 of 22. The rules full stop. Amendments are necessary. Full stop. Application allowed. Let amendment be incorporated within a period of 1 week. Full stop. Also, full stop. Also, amended petition may be filed within the same time. Full stop. Learned Standing Council prays and is granted 6 weeks, 2 weeks. 28th February. No, sorry. नहीं नहीं कर सकते आप ये प्लीज. ऐसी चीजें आप लोग तो कोर्ट में मत कहिए. You understand how things are working. How can you say such a? Do you know कि क्या हो रहा है किसके? You just made a loose statement. The man is going to die. You have declared. You got that power. When you say there is hardship, that's another thing. But you understand what the system of courts is. We can't prioritize every case. इनके में क्या हुआ? कंप्लीट हुआ. इसलिए इनका रखा था कि that was for some purpose. Yes. They served it. That was required to be served on whom? Whose counter?
They are not served the complete copy. They are served the copies at the election.
Where is the other side? If this will conclude today, then let us simply conclude this.
बाद में देख लेते हैं जब तक उसको शुरू करते हैं.
तो क्या हुआ? आ गए. दीजिए ऑर्डर शीट दीजिए. जो कंक्लूड हुए हो गया, आपको मिल गया?
आज
क्यों भाई, किसने यार, आप ही दे देते। Compliance of the last order is stated to have been made today. Full stop. On the request of the state put up 20th, we'd like to close it. जो सुन लिया वो हो जाए, फिर देखा जाएगा। तो जनवरी I will forget. 21st कर दीजिए। 21st to top 10.
Another part is still number 135. Just demand saying sheet people.
So you were at the reading the order yesterday.
Two opinions are there.
Yes.
Problem of opinion which has been taken. So far as the opinion of IIT is concerned, it talks about the examination which was held in September and that was on 13th. Thereafter, paragraph 11 of the order, that is on page 57. Part of it was read yesterday, but I am starting late.
Yes.
दोनों विशेषज्ञों के मुख्य निष्कर्ष निम्नलिखित हैं। डॉक्टर सत्यदेव नंद कुमार ने अपनी याचिका में सेक्रेटरी द्वारा प्रस्तुत की गई थी कि परीक्षक से पाया कि परीक्षा के लंबे अंतराल के पश्चात अभ्यर्थियों की उत्तर पुस्तिका रिपोर्ट की अपलोड की गई, जबकि सीबीटी में अभ्यर्थी के उत्तर मूल सर्वर में तत्काल अपलोड किया जाना चाहिए ताकि अभ्यर्थी के उत्तर रिपोर्ट में किसी प्रकार का परिवर्तन न किया जा सके। यह भी पाया कि मतलब द्वारा जो वीडियो उपलब्ध कराए गए उसमें ऑडिट ट्रेल उपलब्ध नहीं है। यह उल्लेखनीय है कि ऑडिट ट्रेल से पता लगा जा सकता था कि किसी अभ्यर्थी को उत्तर में परीक्षा के पश्चात किसी प्रकार की चेष्टा परिवर्तन किया गया है या नहीं। जैसे डॉक्टर सत्येंद्र कुमार डॉक्टर नंद कुमार द्वारा यह भी इंगित किया गया कि सीबीटी के आधार पर जो प्रतिष्ठित परीक्षाएं यथा जेईई एवं गेट में जो प्रक्रिया बनाई जाती है उन प्रक्रियाओं में मेथड वेबसाइट द्वारा नहीं अपनाया गया, जिससे मेथड वेबसाइट द्वारा आयोजित सीबीटी की सूचिका संदेहास्पद है। उनके द्वारा यह भी आशंका व्यक्त की गई कि अभ्यर्थी के रिस्पॉन्स में परिवर्तन किया गया हो। What the gentleman concluded was it cannot be determined whether any change has been made or not, and what conclusion is being inferred from that is कि रिस्पॉन्स में परिवर्तन किया गया हो। अपने परीक्षा के उपरांत इस निष्कर्ष पर पहुंचे कि अभ्यर्थियों में दागी और बेदागी अभ्यर्थियों को अलग कर पाना संभव नहीं है। डॉक्टर आशुतोष मिश्रा द्वारा ट्रिपल आईटी इलाहाबाद अपनी व्याख्या में यह बताया गया कि सेवा प्रदाता एप्लीकेशन द्वारा परीक्षा के पश्चात अभ्यर्थियों की आंसर की अपलोड नहीं की गई, बिना आंसर की अपलोड की परीक्षा के आधार पर सफल अभ्यर्थियों की सूची जारी कर दी गई और इन्हें हर अभ्यर्थियों का चयन करके वंचित रहना पड़ा। सेवा प्रदाता द्वारा सीडी के माध्यम से परीक्षा परिणाम उपलब्ध कराया गया, परंतु कोई अपडेट नहीं किया गया, जिससे स्पष्ट है कि सीडी का ओरिजिनल डेटा क्लाउड सर्वर में उपलब्ध है। किसी अभ्यर्थियों के रिपोर्टिंग को अक्षुण्ण रखने के लिए यह अनिवार्य है कि ऑडिट ट्रेल उपलब्ध हो, परंतु वेबसाइट लिमिटेड द्वारा ऑडिट ट्रेल की उपलब्धता सुनिश्चित नहीं की गई। जो सीडी उपलब्ध कराई गई उसमें चेकसम उपलब्ध नहीं कराया गया। यदि बाद में फाइल में किसी प्रकार की छेड़छाड़ की जाती तो चेकसम उपलब्ध होने के कारण उसे पकड़ा जा सकता है, जिससे स्पष्ट होगा कि परीक्षा की सूचिका गड़बड़ी हुई है। उपर्युक्त दोनों विषय संयुक्त की आज्ञा से स्पष्ट है कि दिनांक 6/12/2016 एवं दिनांक 7/12/2016 को जूनियर इंजीनियर सिविल व विद्युत यांत्रिक के लिए आयोजित की गई परीक्षा पूर्णतः दूषित है। इस परीक्षा में रिस्पॉन्स शीट के रूप में जो सीडी मेथड वेबसाइट द्वारा उपलब्ध कराई गई उसकी प्रामाणिकता से संदेहास्पद है। सफल और असफल अभ्यर्थियों की रिस्पॉन्स शीट जिसके आधार पर क्लाउड सर्वर में तत्क्षण फाइल सीडित नहीं किया गया और क्लाउड सर्वर से मूल डाटा विलुप्त कर दिया गया है, जिस कारण सीडी में डाटा का में उपलब्ध डाटा विश्वसनीय नहीं है। Finally, see the departure of the conclusion. पूरे घटनाक्रम का अवलोकन से स्पष्ट है कि मतलब वेबसाइट द्वारा जो भी संधि रचित कर पूरी लिखित परीक्षा बताई गई है। हाउ दिस इंफ्लुएंस हैज बीन ड्रॉन। ऐसी परीक्षा में जो प्रक्रिया अपनाई जाती है उसके लिखित परीक्षा के उपरांत निगम की साइट पर आंसर की रिस्पॉन्स की प्रदर्शित की जाती थी, नहीं अपनाई गई। Now lordship may appreciate the word निगम की साइट पर। So who had to upload this answer key at all?
Whatever, निगम छोड़ भी दीजिए, मतलब वो नहीं हुआ. That's a fact कि answers key were not uploaded, objections were not invited, result was declared, and this exercise was done months after the appointments had already been granted.
Then what has to be seen is what is the practice of
effect and separability.
अभ्यर्थियों से प्राप्त आपत्तियों से स्पष्ट हुआ कि अनेक के उत्तर गलत पाए गए। पहले से आपत्ति प्राप्त कर ली जाती तो जिन अभ्यर्थियों को तत्काल हेतु बुलाया गया उनमें से अनेक अभ्यर्थियों को हक न होते और सूची अंतिम रूप से घोषित होती। निगम द्वारा यह भी प्रारंभ में प्रयास किया गया कि इन आपत्तियों के संबंध में नई सूची तैयार की जाए, परंतु IIT कानपुर और IIT इलाहाबाद के विशेषज्ञों की आज्ञा प्राप्त होने से स्पष्ट हुआ कि जो रिस्पॉन्स शीट किसी अभ्यर्थियों को उत्तर पुस्तिका के रूप में उपलब्ध है उसकी प्रामाणिकता संदेह से परे नहीं है। अतः दागी और बेदाग अभ्यर्थियों को अलग अलग किया जाना संभव नहीं है। निगम एवं एक्ट के मध्य जो अनुबंध हुआ था उसमें यह प्रावधान था कि मूल डाटा 1 वर्ष तक संरक्षित रखा जाएगा, परंतु मैसर्स एक्ट द्वारा क्लाउड सर्वर से समस्त मूल डाटा को विलुप्त कर दिया गया और संबंध में शर्त का उल्लंघन किया गया। यह शर्त निम्नवत है। After handover of results in soft and hard copies, Aptech Limited would retain all the data related to examination for at least 1 year, and the support would be provided to various candidates queries. Responsibilities and security of non-leakage of question paper, accurate evaluation and tabulation of marks will fully rest with Aptech Limited. So where is the word cloud data? I put a question to myself. The only allegation is that it has been deleted from cloud server. विशेषज्ञों की आज्ञा से स्पष्ट है कि प्रत्येक अभ्यर्थी की फाइल परीक्षा के तुरंत बाद सिक्योर की जानी चाहिए ताकि बाद में बदलाव न किया जा सके, परंतु ऐसा नहीं किया गया। जल निगम द्वारा आयोजित this conclusion itself is wrong. I will just demonstrate subsequently. I am not addressing all the objections right. जल निगम द्वारा आयोजित इस परीक्षा में 61,452 अभ्यर्थी भाग लिए थे, जिनमें से 853 अभ्यर्थी सफल घोषित किए गए थे। इस परीक्षा में कुछ असफल अभ्यर्थियों द्वारा माननीय उच्च न्यायालय में याचिकाएं आयोजित की गई, जिनमें से श्री अमरीश कुमार पांडे की याचिका दिनांक 21/5/2019 को माननीय न्यायालय में मुख्य रूप से यह टिप्पणी किया था। Now, lordship, with regard to the Mala file, kindly see this observation was modified by the honorable division bench, and still they are referring to the original observation of the honorable single judge. I just read it. This leaves the following question open to Jal Nigam. It may decide to annul the entire selection process if it be of the opinion that the exercise of segregation cannot be undertaken. This would necessarily entail that termination and discontinuance of 656 candidates who obviously cannot be permitted to reach the fruits of selection process, which, as per the respondents themselves, fail to meet the requirement of Article 14 and 16 of the Constitution. The Nigam, if it decides to contend that these 656 candidates are to continue in employment, would necessarily have to take a decision on how the candidature of other candidates is to be processed further. This was only to this figure after modification. So if you are referring to the order of the honorable single judge, then you have to read it modified along with the order of the division bench, because the division bench modified this particular observation to read this figure as 2. Because what is the impression being given? That out of 853, 656 are persons who are undeserving. माननीय एकल
डिवीजन बेंच ने इसको किस चीज को स्टू करा
656 को 250 कर दिया। ये 656 नहीं है, 2 लोग केवल काम कर रहे हैं। सुनी एफिडेविट से मिला है। They have referred that, but this particular observation itself is for with a ulterior intent. माननीय एकल न्यायाधीश द्वारा पारित आदेश के विरुद्ध स्पेशल अपील इफेक्टिव काउंसिल निर्देश की गई, जिसमें 31/7 को निर्देश माननीय न्यायालय द्वारा पारित आदेश के कार्यकारी अंश निम्नानुसार है। The Jal Nigam, being the appointing authority, is competent and it is well within the domain to find out and assess whether the examination has been held fairly and in a transparent manner, and subject to report of the special investigation team, the analysis of forensic lab or any other material that may be placed before the Jal Nigam to take an appropriate action. It goes without saying that such decisions to be taken in accordance with law. The Jal Nigam has also been given liberty by the learned single judge to undertake the requisite exercise of segregation with people of a tainted and untreated candidate. Therefore, the entire matter is now with the Jal Nigam, and the Jal Nigam is to take the conscious and reasonable decision. Now that particular paragraph of the observation made by the division bench where they said कि 656 is a wrong figure and it is to have not been mentioned in this order. जैसा कि दोनों विशेषज्ञों द्वारा यह निष्कर्ष पहुंचा गया है कि अभ्यर्थियों की रिस्पॉन्स शीट जिस पर मूल्यांकन किया गया है ये अभ्यर्थी की वास्तविक उत्तर पुस्तिका है या नहीं नहीं की जाती है। इस स्थिति में जो अभ्यर्थी सफल असफल घोषित किए गए उनकी वास्तविक स्थिति का आकलन सटीक रूप से नहीं किया जा सकता है। जैसा कि पूर्व में उत्तर प्रदेश शासन द्वारा जल निगम द्वारा वर्ष 2016-17 में नियुक्ति में किए गए नेता की जांच करने के लिए प्रकरण को एसआईटी में संबंधित किया गया था। इस अवधि में एसआईटी द्वारा जांच आज्ञा शासन को उपलब्ध कराई गई है, जिसकी एक प्रति नगर विकास विभाग पत्र संख्या 7 डेटेड 18/2/2020 द्वारा जल निगम को उपलब्ध कराई गई है। नाउ दिस डेट इज रेलेवेंट एज रेफर सब्सिक्वेंटली बाय द एसआईटी द्वारा जांच के संचालन में पाई गई आपराधिक कृत्य के साथ मुख्य रूप से निम्न निष्कर्ष पर पहुंचे हैं। आपराधिक षड्यंत्र के तहत मैसर्स एप्टेक लिमिटेड से मिल भगत कर परीक्षा के प्राइमरी डेटा को क्लाउड सर्वर से विलोपित नष्ट कर दिए गए हैं। सहायक अभियंता और अभियंता और नैतिक लिपिक की परीक्षा दूषित होने के कारण भर्ती निरस्त किए जाने पर विचार किया जाना चाहिए। This report was never made public. Only a part of this report they have filed as a supplementary affidavit before the Honorable Supreme Court, which we have brought on record by means of subsequent affidavit. And the only object for filing is that there is no conclusion as they are saying over there, even in that SIT report. In fact, that SIT report, in one of the questions as the investigation officer has put a question to the APTEC, and APTEC's representative has said that I have got the data. What they are saying is कि जो CD provide की गई थी, CD में तो आंसर की provide किया था और merit list provide की थी. They never provided the entire data. Data was fully retained by them for 1 year, and they have filed an affidavit saying because it was still with them. यह उल्लेखनीय है कि जूनियर इंजीनियर परीक्षा के समानांतर सहायक अभियंता की परीक्षा जल निगम द्वारा मैसर्स एप्टेक के माध्यम से 16 दिसंबर 2016 को संपादित किया गया। कालांतर में परीक्षा में हुई अनियमितता को देखते हुए जल निगम द्वारा संपूर्ण परीक्षा को आदेश संख्या 11/2017 द्वारा निरस्त की गई। दिस इज द सेम व्हिच आई हैव प्लेस्ड अर्लियर। इस आदेश के विरुद्ध माननीय उच्च न्यायालय द्वारा अधिक याचिका संख्या 14 में पारित आदेश 28/11/2017 पुनर्विचार याचिका संख्या 14 पारित आदेश के विरुद्ध जल निगम द्वारा माननीय उच्चतम न्यायालय में स्पेशल अपील संख्या 11017 उत्तर प्रदेश जल निगम अजीत सिंह पटेल ने उच्चतम न्यायालय द्वारा दिनांक 15/11/2016 मतलब दिस इज सिविल अपील, स्पेशल अपील नहीं, ये सिविल अपील करना है। दिनांक 15/11/2018 को नोटिस की गई। Appellants have now relied upon the opinions given by the experts in Indian Institute of Information Technology, Allahabad Indian Institute of Technology, Kanpur, as noted in the report submitted to this court dated 20th August 2018. The same was certainly not available to the appropriate authority before the order was passed on 11th August 2017. Indeed, the appropriate authority took into account 2 inquiry reports, but the same did not. This 2 inquiry is not the report of this IIT and IIIT. Those were the inquiries conducted by civil by their chief engineer. That is on the impugn order.
Now relying.
Indeed, the appropriate authority took into account 2 inquiry reports. This was separate. ये opinions है.
वो अलग.
But the same did not evince that any exercise has been undertaken to distinguish the tainted and untainted candidate, or that it was not possible to do so as to upload the decision of declaring the entire selection process as void. Now, what the Ligam has actually done, this pausing for a moment, they have thought it backwards. On this observation, now they are writing everywhere, it is not possible to segregate, and therefore the entire selection is void. Had the appropriate authority done that exercise and recorded its satisfaction in that behalf, to be reflected in the order passed by the chief engineer on 11 August 2017, the High Court could have then followed the settled legal position founded in Union of India versus Joe Chhattisgarh that the nature and extent of illegalities and irregularities committed in conducting a selection will have to be scrutinized in each case so as to come to a conclusion about the future course of action to be adopted in the matter. Further, if the metric played is so widespread and all pervasive affecting the result so as to make it difficult to pick out the person who have been unlawfully benefited or wrongfully deprived of their selection. In such cases, it will neither be possible nor necessary to issue individual so-called notices to each selectee. In that case, the only option would be to cancel the whole selection process and not limiting to one selection of the appointment. This should have been restated in the recent decision of Viren Kumar Gautam, so the dictum of the two judgments relied by the appellants in Court Chakradhar and Vikas Pratap Singh will be of no avail to the appellants in the facts of the situation of the present case. Now, this is related to the natural justice that has been subsequently, I would say, eclipsed by the decision of the Honorable Supreme Court in Article 30. To what extent we can take, because as your Lordship has rightly pointed, it has now become subservient. Once we say that there could be a segregation, then only we can plead the natural justice with regard to the persons who would be otherwise affected. If the entire selection process would, this is my submission. If the entire selection process is said to be non-segregable, or it was there were tainted candidates, or the process was tainted to the extent that no segregation is possible, then probably natural justice will have to give as the court has held in Article 30. जूनियर इंजीनियर परीक्षा में सफल घोषित किए गए अभ्यर्थियों के साथ साथ इस परीक्षा में भाग लिए समस्त अभ्यर्थियों के प्रति जल निगम उत्तरदायी रहे। दोनों विशेषज्ञ के द्वारा दी गई व्याख्या से स्पष्ट है कि संपूर्ण परीक्षा प्रक्रिया दूषित है। काइंडली सी द कंक्लूजन्स एज दे हैव बिल्ड अप द केस। एसआईटी की जांच से यह भी इसकी पुष्टि हुई है। दूषित प्रक्रिया के माध्यम से जो अभ्यर्थी लाभ प्राप्त कर रहे हैं वह दूसरे पक्ष में जो योग्य अभ्यर्थी असफल घोषित किए गए हैं उन्हें न्याय देने के लिए निगम के पास मात्र एक ही विकल्प उपलब्ध है कि संपूर्ण परीक्षा प्रारंभ से वार्ड एडमिशन होने के कारण विधि शून्य घोषित किया जाए। इस परीक्षा के माध्यम से जिन अभ्यर्थियों ने सफल घोषित कर नियुक्ति कर दी गई थी, संपूर्ण परीक्षा विधि शून्य होने के कारण प्रश्नकर्ता नियुक्ति तिथि से शून्य घोषित किए जाने के योग्य है। जैसा कि ऊपर वर्णित किया गया है, इस दोषपूर्ण परीक्षा जिसमें दागी और बेदागी अभ्यर्थियों को अलग अलग कर पाना संभव नहीं है और यह परीक्षा इस सीमा तक दोषपूर्ण है कि परीक्षा के परिणाम से किसी भी प्रकार का सुधार नहीं किया जा सकता और निरस्त होने योग्य है। अतः इस विधि शून्य परीक्षा के आधार पर जो अभ्यर्थी नियुक्ति पा रहे हैं उनके व्यक्तिगत रूप से कारण बताओ नोटिस देने की आवश्यकता औचित्य नहीं रह जाती। उपरोक्त दिनांक 1/1/2017 को निगम की वेबसाइट पर अपलोड किए गए सफल अभ्यर्थियों की सूची तथा कार्यालय ज्ञापन संख्या 21/2017 को निर्गत नियुक्ति आदेश निर्गमन की तिथियों अर्थात 1/1/17 और 2/1/17 से ही निरस्त किए जाते हैं तथा प्रसंगत नियुक्तियां उक्त तिथि से ही शून्य घोषित की जाती हैं। प्रक्रिया के अंतर्गत नियुक्ति जूनियर अब तक प्राप्त हुए वेतन भत्ते आदि का संरक्षण प्राप्त रहेगा, उनके द्वारा कोई वसूली नहीं की जाएगी। विभागीय दायित्व द्वारा निर्वहन की उनके द्वारा उत्तर नियमानुसार किए गए प्रशासनिक और भर्ती कृत्य विधि मान्य रहेंगे। Now, Lordship may appreciate that this entire order talks about two parts. One is the reports of the IIT and IIIT. I will demonstrate again that the report of IIT is not of junior engineer. The reports which were placed before, I'm just refreshing your Lordship. The reports which were placed before the Honorable Supreme Court in the AE's proceedings were a separate report. They can be and must have been with regard to the assistant engineer, the two reports of IIT and IIIT. But the reports which were placed with regard to the junior engineer was for the first time placed by the judge before this court.
Technicality apart, are you seriously contending this? Because all examinations have been conducted similarly. The only difference is with respect to RTGs, routine RGT, routine grade clerks, RGCs, because their examination was held earlier. But otherwise, these are common facts. The report of the whatever two reports existed up to the first stage, the reports of the IIIT and IIT professors, those are not reports of the institutes. Those are not reports, those are not the opinions of the institute, but yes, experts consult who are working at that place.
Yes.
All right. So those are two opinions they have taken. The third material is the SIT. And the fourth material is what they have in their cloud data. The prejudice.
Cloud data.
Their cloud, not your cloud.
Yes.
That they are convinced that there's something wrong that has gone on. So that is driving their inferences.
Or there is an oblique purpose also.
No, don't get into that. No, nothing oblique. But the thing is that they are saying that relying on two objective materials, two sets. One is opinions, the other is SIT.
So what we have to,
And third, if it all is there, again that gets included. What stand apted to before them. So armed on with that, they say that the prejudice caused or the tampering is all pervasive. If they are right in their contention that the data is not available, however they may have worded it, there is no way to confirm if it was available, if it was, or rather if it was tampered or not tampered. One. What then is the secondary evidence? Secondary evidence is the conduct, which is the great hurry in which the whole process is completed. And results declared, people allowed to join, and thereafter answer key uploaded. So that may go against you. But if you are right in your contention that the data is available, it can be verified at this stage also, then this secondary evidence fails into insignificance. Because the primary evidence exists, they have to draw their inference from that.
There is one more data which they are not referring in the improved order because probably they are a bit uncomfortable with that. And that is the report of the forensic science laboratory.
That has come. That has not been considered.
It has not been considered.
You would like to. You have a copy. You have.
Yes, they have filed it in the Supreme Court. We have filed it along with that affidavit.
All.
If
That is one thing.
Page 277. After the order was passed by the division, so the matter was limited.
Other than this, these are the parameters within which this is to be seen.
I'm just substantiating on those.
No, I'm just trying to clear what is there. So, two opinions, one SIT, one FSL. When did you obtain that? That's not been referred to in the order. That you will not, no counter affidavit can improve your case. You may find more material. You may proceed. You may do what you want. But we can't allow you to rely on that.
I mean, I think the report with regard to the question and answer.
When did you obtain that report? After the order, before the order? You have not relied on it. How can we allow you to do it? Unless we demand and then we see. All right.
My Lord. Lordship, kindly at page 277 for a moment.
So
These are the proceedings.
So your submissions, now this is your read out, your submissions are going to be what? There is no material?
I'll be filing my submissions tomorrow in written form, but otherwise.
No, I'm not allowing you to do that.
I have prima facie what I
You may want to.
Prima facie what I am saying is that
Just
these two reports, they have not been referred in complete before in the impugned order.
Two reports, two
opinions.
Two opinions. They have been
Selectively read.
all right,
And therefore the context in which those opinions were given.
selectively read. All right. What is the second aspect then?
The second aspect is that the conclusions drawn in these opinions are not against me. They only show a doubt. And the impugned order goes beyond those opinions to reason. That the
Are doubts, not definite opinions.
Yes. While the impugned order refers to it as a definite opinion.
So, however, impugned order reads more into it. All right. Then
Third is they have relied on that we have not, that Jalligam has not uploaded the answer key in the website. That is the process of Jalligam which has been followed consistently. IIT and other examinations, what they do is not the concern of us. What Jalligam has been doing over the period in 2013 and 2015.
you want others also to come out. Jal Nigam,
My Lord, in 2013 and 2015.
as always, followed the same procedure.
Same thing. We have filed a RTI that has not been
Same
taken.
procedure, that is, they have never uploaded
They
answer.
have never uploaded that. So this cannot be a ground for cancelling. I am not saying it is justified, but I am saying this cannot be a ground for cancelling the selection process. Then, Your Lordship, my third point is that the impugned order refers to the SIT report, which has not been brought before the court in any court of law or tested anywhere, and therefore that cannot be relied by the authorities for taking any conclusive action.
They have not filed it here.
They have not filed a cover. In fact, the statement was made the other day that it was filed without advice even before the Honorable Supreme Court, because it is still lying in the sealed data, sealed cover.
So
So
it hasn't seen the light of day.
yes. Now, Lordship, may kindly apply. There is an affidavit filed by another counsel, it was a very short affidavit in some of the matter, wherein they have said that the SIT report was not given to the Jalnikam. That is a counsel affidavit filed by Jalnikam in some of the matter.
How does that make sense?
This order has been passed
By Jalnikam.
by Jalnikam, not by the state government. You have not seen that SIT report.
ये affidavit किसमें है?
I will be given that number.
UP Jalnikam did not have the SIT report.
Yes.
Already.
In fact, it is still lying in the sealed cover, so they won't be having.
Who has sealed it?
The state government, the SIT is still under investigation. Hello, will be filing. We will be showing that document.
Is who charge sheets have been filed, given all the data, kindly have the concrete necessary details.
You see, we are just trying to ascertain what is the
So,
parameter. Just
I'm
wait.
only correcting, I'm not interfering, I'm only correcting that these are the facts.
SIT report is on record.
SIT report is not on record, but the charge sheets have been filed. Say that
So,
the investigation
all right. So,
is going on.
principally, he is saying that even the Jalnikam has not seen the SIT report. If you show him the charge sheet.
Once the charge sheets have been filed, charge sheets have been submitted. So after that, everything is there.
Oh, Mr. Advocate General, that is a criminal proceeding. But if the chief engineer UP Jalnikam has not seen the SIT report, he could not have been referring to that. That's what he is saying. In the impugned order on the civil rights, the order respecting the civil rights, if the authority has not seen the report, how could he have been adverting to it? That's what he is saying. You may be right that the SIT report was submitted for the purposes of criminal prosecution, and the charge sheet has arisen, and that is not the SIT report is not required to be given to them at this stage. All right, they are not entitled. You need not file it. But if he says that you have not shown, the authority has passed the order, has not seen it, then that's a different consequence. We'll see.
Then, Your Lordship, there is.
Another aspect.
Yes. And that is the report of the FSL, which has not been recorded in the impugned order.
FSL report is favorable to you.
It is with regard to the segregation, and they are finding that no segregation could have been made. It is contrary to that finding.
So that is on the alternative plea.
Yes.
So far as you are concerned.
Yes.
That if at all there is something wrong, then segregation is possible according to FSL.
And then the principle of natural justice will follow, and this order has to go against all, and then they will have
But
to
segregation, segregation part and first aspect also, you are not relying on what APTEC is saying. Because the counsel for APTEC perhaps was insisting that they have filed an affidavit that the entire data is available. I do not know.
Has been filed in writ which is connected with Your Lordship, writ number 6117 of 2020.
Does that affidavit say anything about it?
Yes, this affidavit says that they have got the entire data with checksum, audit trail, and everything, and it was never called.
Was it served on you? APTEC affidavit, has it been served on you?
They have not been served with that affidavit, but affidavit was filed before the Supreme Court.
Same affidavit, taking same stand.
The stand was
Then,
but then the Supreme Court observed in its order that the statement which was given by them, the acting employee, before the society was entirely different.
all
There
right.
he says,
So,
there he says that the data was not updated on the cloud server at all. The data was lost from the cloud server, and the They have not.
What was the status? So what, does the Supreme Court say that look at only that statement?
Kindly have the order part of the order of the
Which one?
of the of 2021.
In the urgency application.
Are in there?
Paragraph number there. Paragraph 44. Page 60. With reference to petitioner's reliance on affidavit filed by the testing agency, the respondent submitted that the onus was on the testing agency to give correct and complete data to the SIT for investigation. It was pointed out that the SIT had recorded the statement of Mr. Vishwajit Singh, technical and delivery head of the testing agency, wherein he stated that the examination data was kept in the cloud only for a month, after which it was downloaded on the local environment, the hard disk. Further, the testing agency had
He has stated that.
Yes.
But where is the
Original training data has been
It does not have paragraph.
No, just wait. Where is the observation by the Supreme Court that therefore nothing else was required to be done by you?
No, I'm not saying that. I'm saying that whatever was stated by them.
That is one
we
statement.
never had the possibility to rebut that.
No, you may not rebut it. We are not concerned with that. We can't reach a conclusion whether it exists or not and what consequences. The question is, you were the person who was doubting. Now, obviously, yes, one statement was made which was going against them, inculpating. No problem. But then there is another affidavit filed, a statement of, that's also a statement made on oath, which states that the data is available. Now, after that, you have made an inquiry to ascertain the correct facts. The SIT has a result. What do you do at that? The order is being passed, not the SIT. The impugned order has been passed after the Supreme Court. Or it was passed beforehand, the Supreme Court passes the order.
Before it was passed before. The order was passed before it. And the order.
So therefore, you will say that there is no occasion to consider that for you at the moment.
Because there are contradictions in the stand which have been taken by the testing agency.
So what? Those are third parties. Rights of whose rights are being affected today?
That's why whatever was provided by them, that was put to the FSL lab. That was testified, and it was found that whatever material they have provided, that has been doctored.
FSL report is there.
Yes.
Yes,
That is the material.
So you are saying that affidavit is not something that the state wants to respond.
That affidavit, what they are saying in
Whatever they have said, they have said after the order has been passed, and that is not for you to consider. All.
Lord, may kindly have paragraph 37 of this order. On page 56.
Why?
My Lord, it is with regard to the same context of this kind of.
This is again a submissions. Now, what can we do about it?
Yes, but kindly appreciate that lastly the Honorable Supreme Court in the last penultimate paragraph has said that we leaving all contentions other than decided in the judgment open to the respective parties to be raised before the High Court. So neither that particular part nor this
Question
particular part.
is, Mr. Mishra, when did the APTEC file that affidavit? After the impugned order, before the impugned order?
My Lord, it was filed in the proceedings in the writ petition. Before that, they were not even aware of because they were never called upon. That is their stand.
Which writ petition?
The petition challenging
Therefore, that becomes that is not a material that we can outrightly consider to test the order, correctness of the order 2/3/2020. That affidavit has been prepared subsequently.
Yes, but
So therefore, on the test of judicial review, how can we just allow that readily read that material? We'll have to wait. If there is required, we'll see what is to be done.
Yes.
But that doesn't become
so.
yes.
Lordship, may I place the opinions in its complete?
With
It is on page 217.
already do tomorrow. Start from there. You are really going to read that opinion is in the part of the writ petition now.
Yes.
कल कितने फ्रेश हैं?
20
20
20 में है और 14 + 6 है, 6 जो है डेट फिक्स वाले 14 नए 6 डेट फिक्स वाले ऑप्शन का कंप्लीट 5 ही केस
Arguments of responsibilities are continuing put up tomorrow. वो गलत है क्या? नहीं ठीक है।
मैसेज मतलब हो बाद में मैसेज मैटर सेल नंबर 31
काउंटर what does this state